Well, hello everyone who is here. Today we're going to be talking about the Tenant Committee of 7. This is the statutory version of a committee, a tenant committee. The law that governs this tenant committee is found in ORS 90.600 subsection 8. I am Samantha Sheehan. I'm a staff attorney at the Oregon Law Center, and I have a special grant that allows me to work on manufactured home parks and floating home marinas. So today we're going to go over, we'll do a brief introduction of myself, my position, and what we're doing here today in this presentation. Then we'll go over the law. Ken mentioned briefly at the beginning of this that the law is rather sparse on the issue. So we'll go over that law, we'll talk about what's in the law, and then we'll talk about kind of what's not in the law. And sometimes what is not in the law is just as important as what's in the law, because that's what the attorneys get to argue about. And so, as I'm sure, I know that Jim said he's experienced this, and I know that lots of parks experience this as well, is that because the statute's so bare, people follow kind of their own process for setting up the committee. And then, of course, right, like I said, what's not in the statute is just as important. Those landlords will come back and argue that you didn't meet the statute because something is implied, right? And so we're going to kind of talk about that, what it means to not have things in the law, and what you guys can do to kind of preemptively deal with those potential objections. Then we're going to talk about forming a committee, the what, the why, the who, the how, all of that good stuff. Then we'll go into the rights and duties of the committee. This hits on what Ken talked about at the beginning as well, that this is a really long-term commitment, right? This isn't just something that you're going to do once. You don't just form the committee, hold one meeting with your landlord, and all your problems are solved. That's really not a realistic expectation for this type of committee. But there are rights, there are duties for this committee, and depending on how you leverage those rights and duties, I think will determine how successful your committee is. Then we're going to talk a little bit about what resources are available to you all. I have been working diligently to come up with a very extensive packet for the Committee of 7 with detailed instructions, with sample ballots, sample letters, sample flyers, all of that kind of stuff, so that you guys have everything that you need to be able to set up one of these committees as easily as possible, while still following all of those kind of minute little requirements, to make sure that that landlord doesn't object to your formation there at the end. And then, of course, we'll have some time for Q&A at the end as well. All right, so my name is Samantha Sheehan. As I said, I'm an attorney with the Oregon Law Center. I have a special grant that was created in the Senate Bill 586 back in 2019. That position was extended and expanded by House Bill 3151 that was passed back in 2023. So my position allows me to represent low-income facility tenants across the state of Oregon, as well as provide training and develop resources for tenants as well across the state of Oregon. As I mentioned, this applies only to facility tenants and facility tenancies. Those tenancies are governed by what we call the back half of ORS 90. That's 505 through 875. These laws are different than what you find in the front half of Chapter 90, which governs apartment tenancies. It's pretty self-explanatory for the reason we do that. When you're a facility tenant, you own your home, right? You're just renting the space that your home is located on and renting essentially your access to common areas and the facility itself, right? Whereas an apartment tenant, they don't own any of the infrastructure, right? So they're renting the land that the home is located on, as well as the home itself. So a landlord's duties for an apartment tenant are going to be much different than a landlord's duties for a facility tenant, because the landlord has no ownership right in your home. And they also don't have a right to force you to do things inside your home, right? Like the inside of your home is your domain in this type of a relationship. Whereas in apartment tenancy, it's still the landlord's domain, although you have that right to possession. So that's why we have different laws for these facility tenants, because the situation is certainly different. You have that ownership right, and these laws are here to protect that ownership right. The main caveat, this is not legal advice. I cannot provide anyone here today with legal advice. This is simply legal information. I am giving you information about what the law says and how to use that law to your behalf. What legal advice is applying the law to specific facts of someone's case. So if you have a specific question, like you say, hey, I did X, Y, and Z, and now my landlord is doing A, what should I do? That's a legal advice question and not something that I'm going to be able to answer for you here today. If you do think that you need legal advice, I suggest reaching out to your local legal aid office and conducting an intake. If you're over income for your local legal aid office, but below 80% of the average median income for your county, you could reach out to Ken, who can put together a referral for my office. I start taking referrals again on February 1st, so in just a few days. So if you can wait 2 days, then you can go ahead and apply for my services as well. I do have a slightly higher income level than most of the local legal aid offices in Oregon. And you can find that income level by searching Oregon average median income by county. It is on the Oregon Housing and Community Services website where you can find that information. But generally speaking, you're looking at in between about $40,000 to $60,000 per year for a household of one person, depending on what county you live in. If you live in Multnomah County, you're going to be looking at a higher number for your average median income than you would, say, if you were looking at somewhere more rural, like Hood River, right? So it does change by county. If you have questions about that, we always screen for your financial information when you apply. So if you don't know whether you'd be eligible or not, that's okay. We will screen for that, but just a warning that if you are over income, we cannot provide you with legal advice or representation, and you will be rejected at that point. All right, so let's chat a little bit about this law. As we mentioned before, the law is relatively sparse. So this right here, the text in white, is the entire law regarding a tenant committee of 7. So essentially, if you break down what this law contains, you have some language about the formation of the committee. So in order to form the committee, you need to hold a park-wide election. 1 vote is allowed per rented space, and you may elect a maximum of 7 members. But of course, fewer than 7 members is okay. You just cannot elect more than 7. As you can see, it doesn't really give us much information about what a park-wide election is, right? So that's something that we're going to talk about. This is often the point of the sticking point for a landlord. They're going to try and argue that you did not hold a facility-wide election. And so this is something that we'll talk in depth about, of how to hold that election properly so that there are no, there can be no objections, right? The statute also talks here a little bit about committee rights. So what's the purpose of the committee? What does the committee have a right to do? Well, the committee has a right to compel the landlord to meet with the committee to discuss the park issues and concerns up to 2 times per calendar year. The meeting shall be held on the premises or another convenient location, and the landlord has to essentially respond to the committee's summary within 60 days of receiving that summary. So the committee duties are that once the committee has made a written request to the landlord to schedule that annual meeting, then the landlord will attend that meeting with the committee within 10 to 30 days. After the meeting, the committee will write a summary of the issues and concerns that were discussed during that meeting, and they will send that summary to the landlord. The landlord then has to respond in writing to that summary within those 60 days of receiving the summary, right? Not 60 days at the meeting, but in 60 days of receiving the summary. The remedies that are included here is that if the landlord fails to meet with the committee or fails to respond to the committee summary within 60 days, then the committee may be entitled to informal dispute resolution. We will talk a little bit about what informal dispute resolution is, but just a quick note that it is different than mandatory mediation. It is set forth in a different statute, and the landlord is not required to participate in informal dispute resolution. Another point is that the informal dispute resolution, the policy, the procedure that you would use to request this type of IDR will be found in your rental agreement. So, as we talked about, this statute isn't detailed. There's not a whole lot here, right? We're working with one section of a statute, and this one section is supposed to tell us how to hold an election, how to run a committee, and what the rights of that committee are and its remedies. So that's a whole lot of power condensed into a very short section of law. This can be problematic. Sometimes people say, oh, well, the law is very general. That's good, right? You can interpret it in any way you want. And while that may be true, that is also true for landlords, right? So that means that if a tenant can interpret it to require very little, a landlord can interpret it to require a lot. And really the only way that we can determine what this statute actually requires with certainty is for a judge to make that determination. As you guys have experienced, the amount of resources available to tenants in Oregon is not great. There are a few private attorneys that do tenant work in Oregon. And then, of course, there's Oregon Law Center and the Legal Aid Services of Oregon who provide services to tenants as well. However, like I mentioned before, Legal Aid and Oregon Law Center have pretty strict financial eligibility requirements that require you to be pretty low income. I am the only attorney in the state of Oregon who provides free legal services to facility tenants who can make more money, right? Who are about 80% of the average median income. So generally speaking, when you're looking at legal aid, you're looking at closer to like 30% of the AMI, right? Maybe 40, depending on the area. So I'm about double what that financial eligibility, what your income can be, which is great. That is increasing the amount of services available to facility tenants in Oregon and making sure that, it's not just people who are the poorest in these parks, but that most people in the parks can access resources. However, as I am only one person and the state of Oregon is quite large, there's a very clear restriction on my capability to represent everyone and what types of cases I'm able to take. Given all of these concerns, knowing that there's not really an option for tenants to bring a case based on their kind of lax interpretation of what the statute requires, my position has been to adopt a strict reading of this statute, adopt a strict procedure that follows the statute, develop resources that are very professional and look as though they are an actual election, right? This way, we basically undercut every possible objection your landlord may have, every reasonable objection your landlord could have and bring to this, to say you didn't set this up correctly. That I'm so sorry, people keep messaging on Teams and it's distracting me. I apologize. Let me get my head back on straight. So the procedure that I have adopted and developed takes into account all of the objections that I have thus heard from landlords and their attorneys so far in my work in the past year and a half or so in this area of law. I've taken into consideration all of those objections, and I have created a process that deals with all of those objections. The reason I have done this is because at the end of the day, if you have done an election that is absolutely reasonable, that takes care of any potential concern that the landlord might have, like your tenants don't know what a committee of 7 is. They're not sure what they're voting for. Did you give them an opportunity to vote against the committee? Did you, make sure that the people who were running in the election were like that people wanted them to run, that they had support? Did you hold a meeting initially to explain to tenants what this is and why they would want one, right? There's all sorts of things that I've seen landlords object to, and all of those things are what I used to develop my system. The reason I did this is because if you don't follow, if someone comes to me and says, hey, my committee is not being recognized by my landlord, and I say, okay, but what process did you use? And they kind of show me their process, and that process, that there are reasonable objections to that process, then that is not a case that I would be able to take for litigation, because I have really limited resources, right? So if I took a case where you could have followed a stronger process, but you didn't, and we go to court on that case, I'm spending a ton of resources on an issue that could have been resolved by simply using a stricter process in the first place. Now, on the flip side of that, if you use this strict process, if you resolve all of the reasonable objections in the first attempt and your landlord still won't recognize you at that stage, that is something that I would be interested in pursuing litigation on, because I can say that we have a very, very reasonable argument. We've done everything that the statute could possibly, in any reasonable reading, require of us, and the landlord is still not recognizing it. That, I believe, is a very meritorious claim and is something I would be interested in. But again, I don't have the resources to litigate this issue in terms of what's reasonable for the statute to be required and what's not, right? So what we've done is put together a giant list of what we think is a reasonable objection, and our process makes sure that we don't do any of those things, right? So we're going to be talking about a pretty strict process here, and I want it to be very clear about why I recommend using this process and why I would not take a case from a park who did not use this process when they're wanting their landlord to recognize them. Does that make sense to everyone? Does anyone have any questions about why I would not take a case if you've not used this extensive process? Don't think I see any hands or anything in the chat, so I'm just going to go ahead and move on, but please feel free to pop a question in the chat or raise your hand or just speak up at any point. I'm happy to be interrupted. I talk a lot, so please feel free. All right. So a brief note on informal dispute resolution. We generally call this IDR because informal dispute resolution is a mouthful. So IDR is not mandatory mediation, as I said before. Mandatory mediation is a right that's held by facility tenants, so the individual and also the landlord by management. The law sets forth that right in ORS 90.767. So mandatory mediation, it sounds like it's mandatory for you to resolve the problem. That's not what is mandatory. What is mandatory is that the other party participate in the process. So it doesn't require that a solution is reached, just that the parties attend the scheduled mediation sessions. The right to IDR, so informal dispute resolution, is created by your rental agreement. So in order to determine whether your committee has the right to engage in IDR with your landlord, you got to review your written rental agreement to review the section on IDR in your written rental agreement, and that should set forth who can request IDR, how to request IDR, and when. Because this is set forth in your rental agreement, different parks likely have different policies regarding IDR and its application. So whereas one park may give IDR rights to a committee of 7, another park may not, right? And that is okay. The law says that landlords are allowed to create an IDR policy and that policy needs to be in your rental agreement. Whereas mandatory mediation is set forth by law, it's required. That is also going to be in your rental agreement, but there's also a statute that sets forth those requirements. So IDR is different in that way. ORS 90.6769, sorry guys, use my little scroller on my mouse, there we go. In addition to mandatory mediation required under ORS 90.767, a facility may establish an informal dispute resolution procedure that ensures each issue with merit is addressed within 30 days after receipt of a formal complaint. So again, here you see a facility may establish. That is permissive language. That means that a facility is not required to establish this policy, but they may do so. If they do so, then that procedure needs to ensure that each issue with merit is addressed within the 30 days after receipt of the formal complaint. And again, so this bottom thing here, ORS 90.769, this is what a committee would have access to. Not mandatory mediation, but informal dispute resolution. And again, only if that procedure is set forth in your rental agreement and allows that committee of 7 to participate in it. So what is a committee of 7? So it's a legal right held by facility tenants. That right to form a committee of 7 is found in ORS 90.608. It's what we just discussed above. A committee of 7 is made up of 7 or fewer members. Those members must be facility tenants. Those tenants need to come from separate homes as well, right? So you can't have one home in the park with, say you've got 7 people living in that home. You can't have all 7 members come from that one home in the park, right? You can have 1 member per rented space, and just as you get one vote per rented space. You're elected through a park-wide vote. So they're all park facility tenants and must have the opportunity to vote in the election. Again, each rented space gets 1 vote. The committee of 7 represents the interests of park tenants. So again, this goes to the longevity and the long-term commitment of this type of committee. This is not a committee where you just get elected and then you get to do what you want to do. Your job is to represent the interests of the park tenants. It is not just to pursue your own interests. It is your duty is to meet with park tenants, to have open communication and transparency with park tenants, and have gain an understanding of what concerns and issues all the tenants in the park are dealing with, and then using that information to essentially to inform what types of things you're going to raise in those meetings with your landlord, right? So it is not an internal thing. This is something where you need to have that communication. You need to have outward meetings. You can't just meet internally all the time. You do need to have that contact and have that an open communication with your park tenants and make sure that they feel as though they can contact you, that they can come to you with their issues, and that you hear them and react to them as well. Just going to take 1 second here, guys. I'm trying to turn these Teams notifications off. I get very distracted by noise, and so it's killing my distractions. All right, let's see here. Okay. So why would we want to form a committee of 7? As Ken mentioned, really the only thing in the law that you that the law provides that you can do as a committee is to force the landlord to meet with you once, but not more than twice per calendar year. Then you could send them that summary and then they respond to you, right? So that's what statutorily, that is the purpose of the committee, and that's why you would form one. However, there are a lot more tangential advantages to forming a committee of 7, and some of this has to do with the people that you elect to the committee of 7 and their level of commitment to the committee. But one of the things that I think is the best part about having a committee is that it increases tenant resources, it increases morale, and it increases your bargaining power. So the committee of 7 provides a centralized tenant resource within the park. When something is going on with one tenant, they can reach out to the tenant committee right away and say, hey, I just received a notice of termination. What should I do? The committee of 7 can have and maintain a list of resources and information for facility tenants. For example, the committee of 7 could have a list of could have the local legal aid office phone number and email address. They could have my intake information on there. They could have OSTA's information. They could collect handouts that are posted on different legal aid and legal resource websites that they can hand out to people. They can have the eviction defense project number, right? And know when to give that referral out. So if there is a centralized committee in your park that has access, that knows about resources, that keeps a list of these resources, that keeps a bank of handouts and other informational resources, when something occurs within the park to one tenant, they can go ask the tenant committee. That can be their first point of contact, and the tenant committee can help connect that person with either the agency, the legal organization, wherever, that would be beneficial to them in their specific legal problem. That can be incredibly helpful because oftentimes we see more vulnerable tenants in a park just really not know what resources are available to them. They may not have internet access to perform the necessary Google searches. There's all sorts of reasons why people may not understand or know about the resources that are available to them, but they should know that they have a tenant committee, and they should know the phone number or the email address for that tenant committee and be able to reach out easily and get a response quickly. And that can really help the tenants in your park get connected with the resources that are available to them, because there are a lot of resources out there, including resources, to help. Like Habitat for Humanity will often help homeowners, which facility tenants are homeowners. You own your home, even though you rent your space. Habitat for Humanity will often help homeowners replace windows or, take care of things in the lawn that need to be taken care of in order to cure a violation notice or a termination notice, right? So resources are available. A big part of accessing those resources is just being able to know who to call and know what types of services they provide, right? And so that is a huge, huge benefit of having a committee. The committee should also host town halls and foster community building within the park. So town halls would be an opportunity where the committee of 7 would sit up front. They would run the meeting, but would allow all tenants of the park to attend, to voice their concerns, to bring up new issues, to suggest what types of things they want to negotiate with the landlord on, etc. Right? They can also foster community building by maybe, suggesting the creation of an activities committee where people who maybe are not on the actual committee of 7, but maybe 2 or 3 people in the park who really enjoy putting together events, could be appointed to host maybe quarterly events within the community. These types of events, these types of get-togethers are incredibly useful in terms of, again, building that trust, building that community between tenants, so that when something occurs to you, you feel it's easy and it's the right thing to do, and you feel like you know the person well enough to go ahead and go talk to them about what the issue that you're facing is. When we face issues all by ourselves, when we do things in isolation, we often miss out on the opportunity, number one, to connect with other people who are facing the same thing, but number 2, to then join it with those other people who are facing the same thing to increase your bargaining power. 3 tenants with the same issue arguing with the landlord is going to have more bargaining power than one tenant with that issue arguing with the landlord. When you've got 3 tenants with the same issue trying to resolve that with the landlord, that means you have 3 times the damages, right? Generally speaking, one tenant gets whatever statutory or actual damages are due to that one tenant. So if you have 3, now that's times 3, right? And so that increases your bargaining power with the landlord. It means that if they don't do what you've asked them to do, then their consequence is going to be much more expensive, right, than it would be just bargaining against one person. When the committee is bargaining with the landlord in these meetings, it represents the interests of all facility tenants. So the committee can say something as, it's come to our attention that, you know, the majority of facility tenants in this park are concerned that you are overbilling, that the utility billing is incorrect in our park. We're letting you know right now that you have the chance to address this, but if you don't, then the facility tenants are interested in pursuing litigation. That threat of litigation against the landlord by all the facility tenants, right, or by a majority of them, can be very overwhelming. If you're looking at 1 month's rent of damages per tenant, well, one tenant, that's not that bad, right? 100 tenants, that can get very expensive very quickly. And so it's the threat of collective action that increases your bargaining power. Again, we've discussed this before, but the committee has access to the landlord. They can compel the landlord to meet with them at least once, but not more than twice each calendar year. Whether you can compel them to meet you once or twice is going to be set forth in your rental agreement. Generally speaking, landlords put once in there. So the law only requires once. If your rental agreement is silent on the issue, it doesn't say how many times the landlord has to meet with you, then that would be twice. Now the parties can agree to either more or just once, but you would have to agree to that. You don't have to sign every single piece of paper your landlord gives you. If you establish your committee and your landlord gives you a committee agreement that says, I'll only meet with you once, and whatever, they try to put their own terms in there, right? Any contract, any agreement is supposed to be a meeting of the minds. And if you don't agree to a term in that presented contract, then you should go ahead and scratch that out, attempt to negotiate that with your landlord, right? So just because your landlord gives you something to sign does not mean you should sign it. Review it, make sure you do agree with those terms before you sign it, because once you agree to something, then that is going to be the term that applies throughout the life of the committee, excuse me. One of the other main advantages of forming a tenant committee of 7 is that you have a huge advantage in the park purchase process. So under Oregon ORS 90.842C, facility tenants can compete to purchase the park as a cooperative when the landlord intends to sell the park. So if a landlord intends to sell the park, they're going to have to serve you with a notice of intent to sell. Once you've received that notice, you have 15 days to form a purchase committee or identify the purchase committee, and deliver in writing to the landlord the intention to compete to purchase the park. Obviously, 15 days is not a very long time. We're going to be talking about how to form a committee of 7 here in a minute. And the process that I'm going to suggest is not a quick process. This process generally takes at least a couple weeks, if not a month. And that's obviously impossible to complete in 15 days. So having a committee set up already and having discussed with the park already whether the park would or would not like to compete to purchase the park should the landlord intend to sell, you already have a committee set up, right? You already have the people ready to go. They can call an emergency meeting, they can discuss the sale of the park, and they can get that letter out to the landlord, right? The committee could even preemptively have a draft letter that would go to the landlord, right? So then they're not wasting time attempting to draft the letter in those 15 days. So having a committee already set up that represents the interests of the tenants, a committee that already holds town halls, a committee that perhaps has collected tenant information and has a phone tree or an email list, right? Or has the ability to pass out flyers quickly, right? So has processes put into place where you can get a hold of the tenants quickly and efficiently so that you can feasibly put together this notice of intent to compete in that 15-day timeline, right? So I think, again, this is a huge one. The fact that Oregon allows tenants to purchase, gives tenants the right to compete like this is huge, right? Because once you form your park as a cooperative, you no longer have a landlord. You're your own landlord, right? And you get to set the terms, you get to decide whether or not you're going to complete improvements, whether you're going to raise the rent, all of these things, right? You of course you have a mortgage, so I guess you could say that your bank's your landlord. But yes, at the end of the day, purchasing the park as a cooperative and becoming a cooperative is a huge advantage for tenants. It's a great program that we have in Oregon, and we do have resources available to tenants to come up with that funding. So one of those organizations is called CASA. Can't remember what that stands for right now, but Rose Ojeda is one of the main people who deals with tenants there and helps them put together these, essentially their park purchase, get the funds together, right? She's incredible. She's so helpful. And so there are resources out there, right? You might think, well, we can't afford to do that. Well, there are resources out there very specifically designed for tenants to be able to get the funding that they need to purchase a park. And I saw that Ken had his hand raised. Oh, you're muted, Ken.
There we go. I wanted to mention CASA basically is the group that assists tenants in developing a response to a purchase, basically, and they will review all of the aspects of what it takes to put together a bill, a response, or a plan to purchase, whatever you want to call it. And they again, it's Rose and that whole team over there. And if you get a notice from a park, it should tell you to theoretically, it should tell you to there is a contact given on who you contact, but also statute requires landlords to send a notice to MMCRC. This doesn't always occur, but you can always call the MMCRC office and get a reference into CASA in case you forget exactly who CASA is. But again, they're set up and they are supposed to notify MMCRC, and we get that notification or even a hint of it, we'll be able to direct you to CASA directly. That's all.
Yeah, that's a great point, Ken. And like perhaps at some point in the future too, we can put together like a park purchase presentation, maybe a shorter one, but that we could see if Rose would be willing to join us and possibly, create some resources for that as well, because the 15 days is just so quick. And really that intention notice, I don't think it needs to be super detailed. And so perhaps we could get something like that out. Because I know, sometimes it's hard to get connected with someone and get something drafted in those 15 days. And so if we can, so we'll work on that on our end of making sure that you guys have access to that type of information as quickly and as concisely as possible. But again, I think that that's just a huge advantage of setting up a committee of 7. Like I said, you don't have to wait until you get the intent to sell from your landlord to discuss whether or not you would like to form a cooperative should this opportunity arise. So you can do some preparation before that 15 days even occurs, right? Who can participate in a tenant committee of 7? Facility tenants only. So tenants who rent or who own their manufactured or floating home and they rent the space within the park or marina. Some tenants in parks, so some parks are like multi-parks, right? Where you've got some facility tenants and you have some regular apartment tenants because say the landlord maybe owns 4 of the homes within the park. So they rent those homes and the space out to some people, whereas the rest of the homes are owned by the tenants and just the space is rented. So you can have a mixed park. The only people who are eligible to participate in the vote and the committee and the people who are represented by the committee of 7 are the facility tenants. So the people who own their manufactured home and rent the space. As I mentioned at the top, the law is different, whether you're an apartment tenant or you're a facility tenant. The right to form a committee of 7 is found in the facility tenant part of the law, meaning it does not apply to apartment tenants. So if you do have apartment tenants in your park, if they live in an RV, if they're renting the actual home as well, those people are not eligible to participate. Only 1 vote per household is allowed. So each rented space in the park may cast only 1 vote in the election. It does not matter if you have 5 people living in your home, only 1 vote is allowed to be cast for that household. It is up to the household, up to the rented space, how they're going to decide who to vote for and what to vote for. They can all sit down and do it as a team. They can appoint 1 person. They can say, oh, well, that person's on the deed, right? So they get a vote. It doesn't matter how they decide to do it, but only 1 vote per household may be cast. Similarly, only 1 member per household may run as a candidate in the election. So again, if you've got 5 people living in your home, you can't have 5 people on the ballot running as candidates in the election. Only 1 person per rented space may run as a candidate in the election. I recommend that applications for candidacy are used and that only those who have filled out and completed the application for candidacy and returned it by the deadline to the election coordinator should be included on the ballot. This ensures that each person who is running for candidacy has some support within the park and ensures that you don't just end up getting 7 people saying they're interested in the committee, then you've got 7 people on the ballot. Everyone in the park simply votes for those 7 people. And now you've got 7 people on the ballot or 7 people on your committee, but perhaps all of those people are not super invested. Perhaps those people are not really committed to doing the work that's required to have a successful committee, right? An application for candidacy merely requires that that the applicant review some of the terms of what is expected of them and to sign a statement saying that they agree and want to participate in that committee and agree to those kinds of commitments. It also requires them to receive a couple signatures. The application that I drafted has 5 signatures. That would be for use in a larger park. If you have a smaller park with only 25, 30 spaces, you're probably going to have less you'll probably want to require less signatures to get onto the ballot. But I think that it ensures that those people who are running do have some support from other members in the community and that those people are informed of what is going to be requested and required of them once they make it onto the committee and have signed something saying that they agree to do that. And that's before they even get on the ballot, right? And so I personally think it's a great way to kind of ensure long-term success of your committee and also to ensure that that there is that kind of representation, right? That these people who are on your ballot did have some support even before they got on the ballot, that it's not just one random person who maybe disagrees with every single person in the park on every single issue and is really outspoken and wants to get on that committee and runs and ends up getting voted in because there was only 7 people on the ballot and people voted for 7, right? So you want to make sure that the people on your ballot do have support and are going to represent the interests of the rest of the tenants in the park. So now we're going to be talking about the formation process. how do we form a committee of 7? First, you're going to have a kickoff meeting. Then you're going to go through the appointments and applications process. So you're going to appoint an election coordinator and tally assistants. And then you're going to distribute those applications for applications for candidacy, and set the deadline for when those need to be returned to that election coordinator. Once that deadline has passed, the election coordinator is going to complete the ballot with those people who have put in their applications for candidacy and have submitted completed ones. The election coordinator will add those people to the ballot. The election coordinator will make sure to add in all of the information on the ballot that is specific to their park. What is the time and date of the deadline? Where is the ballot box located? Where are additional ballots located? Who can they contact with questions, right? All of these make sure that the instructions on the ballot are complete. How do you vote? How do you fill it out? Do you put a check mark? Do you fill in a bubble, right? All of these types of things, the election coordinator needs to review the ballot, make sure that the ballot is complete, and that all of your candidates are on the ballot and all of the information is correct. Then the election coordinator will distribute those ballots to everyone in the park. I highly recommend keeping track of all of this. An easy way to do it is to simply make a simple Excel spreadsheet, print that out, and as you're passing out each ballot to each house, simply write on the paper, space X, gave it to this person, and get a brief signature from that person when you obtain the ballot. One of the things that landlords will and do object to all the time is that you did not provide ballots to every tenant in the park. Obtaining signatures and tracking how whether you gave it to them in person, whether you posted it on their door, and keeping track of all of those things in one centralized location you can literally just then provide that to your landlord and say, well, actually, we did provide it to everyone. Here you go, right? So again, it's trying to kind of preemptively think, what kind of objections is my landlord going to have? And how can I make sure that I have everything I need to say, screw you, landlord, we did that already, right? So that's the vote. Once all the ballots are out, tenants will have about a week to fill out the ballot, return the ballot to the ballot box. Once the ballots are returned and the deadline has passed, it's time for the results and the commencement. The election coordinator and the tally assistants will count the vote count all of the ballots after the vote has completed. They'll check those ballots for accuracy, making sure that only one ballot per rented space was returned. And then they will tally the votes. So the votes will be, the ballot has two parts. One, do you want to set up a committee of 7, yes or no? And 2, who do you want to elect? And then you've got the list of elected potential people to vote for, right? And so the election coordinator and the tally assistants will go ahead and do all of that together. They'll write up a notice of election results, distribute that to the tenants, and provide that to the new committee of 7. And the new committee of 7 will hold their initial meeting and plan for their first town hall to discuss priorities and goals with the rest of the tenants. Once the committee has met internally and appointed their positions, they will go ahead and notify the landlord. Essentially, they say, here's the process that we used. This is how the vote turned out. We now have a committee of 7, and here are the people on that list. That notification really should be clear that you are not requesting a meeting, that you are merely letting the landlord know that you have formed. You want to wait to request that meeting with your landlord until you have held a few town halls, until you've been able to establish your committee goals and your mission, your priorities, right? Because you only get one shot at this per year, generally speaking. So you want to go into it as organized as possible. And again, you're there to represent the interests of the tenants in your park. So if you've never even met with all the tenants before you meet with your landlord, you're not doing your job. You're not representing the interests of the tenants because you don't know what their interests are because you haven't met with them. So make sure that that notification to your landlord is very clear, that you are not requesting a meeting, rather you're notifying them of your existence. So that's the general overview. We're going to go into a little bit more in depth of each of these steps here next. So kickoff meeting. So at least 1 week prior to the kickoff meeting, you want to distribute an informational flyer to every home in the park. You can see that here's an example flyer. You want to make sure that the date, the time, the location, the topic is all very clear. You can see here that there's some information about that the law gives you a right to form a committee of 7, that the committee represents the interests of the tenants, a brief overview of the rights of the committee, and then the purpose of the meeting, which is to discuss establishing the committee. This notice also contains the law regarding a tenant committee of 7. I think one of the things I've seen landlords object to is that that the communications did not clearly set forth what a committee of 7 is and what it can do. And so by simply including the entire law in your first notice about talking about the tenant rights and forming a committee of 7, I think very, very clearly meets that requirement. And again, these are things that you can then attach to your letter to your landlord when you say, hey, we formed a committee of 7. You can attach all of these flyers and letters that you've sent out to tenants as proof that you've given all of the information to tenants that you were supposed to. So during the kickoff meeting, you want to, as I mentioned, appoint an election coordinator and tally assistants, either 1 or 2, but you want to at least have 2 people reading the vote, right? Not just 1. If only 1 person reads the vote, that can bring up concerns of accuracy and concerns of possible like fraud or something. So you always want to have at least 2 people in there so that there's a secondary person who can attest that this is, yes, in fact, the right information. Those people cannot run for the committee. If obviously you don't want the people that are counting the votes to have an interest in who wins, and you certainly would have an interest in who wins if you are one of the people who could win, right? So if you are the election coordinator or the tally assistant, you can't run in the election, but it is important that you appoint both of those people. The election coordinator in particular is very important during this process. If you do not have 1 person centralized and running this process, it's going to be incredibly chaotic, and it's going to be really difficult at the end to explain your process to the landlord. So you want to centralize the coordination of this election within 1 to 2 people. At this meeting, you'll also distribute applications for tenancy. Nope, that's a lie. I always say that. Applications for candidacy, not tenancy. Please ignore that. Applications for candidacy. So you'll have those available at the meeting. If anyone is interested in running for the committee, they can pick one of those applications up at that meeting. Those applications should be made available throughout that next week prior to the deadline for turning in those applications. You're also going to want to keep detailed records at this meeting. It might be a good idea to do a voice recording of the meeting, and or have someone there with a computer taking minutes of the meeting. You'll also want to set out an attendance sheet so that when people come in, they can sign into the meeting. This way you can explain to the landlord if they ever ask, well, we had 80% of the tenants show up at our kickoff meeting, right? So again, you just want to keep a really good record. If you think about it, like, you want to be able to prove objectively everything that you did in your election. So try to keep records with that in mind. And of course, during the kickoff meeting, you're going to be discussing the benefits, the risks, what is a committee of 7, how to do the election, all of that kind of stuff you're going to be discussing at this meeting. And hopefully this meeting will determine whether the park does want to move forward with an election or not. And then, you can kind of kick off from there. Occasionally, you may need to hold a second meeting. I've seen that happen in parks where, there were a lot of questions and maybe some of the answers were not available at the time, and so a secondary meeting was required. If you feel that's necessary, I think you should do it. Again, I think caution is the best way to go in this election process, because, yes, it might take you a teeny bit longer in the first time around, but it's much better than having to do it all over again if your landlord fails to recognize you. So the application period, here's an example application for candidacy. Essentially, like I mentioned, you would get 3 signatures, or you'd get up to 5 signatures from other tenants in their other facility tenants in the park. And then here is the attestation, basically, that says I agree to the terms of candidacy. I own my own park and rent the space. This is my space. No other residents are applying for candidacy. Each supporter listed on this rents their space and only 1 resident per candidacy. And I understand that I have the legal authorization to negotiate with on behalf of the park. And I understand that if I'm elected to the committee, I will serve to the best of the abilities and represent all the interests of the tenants in the park. So again, this is just really ensuring that each person who gets on your ballot knows, understands, and agrees to the terms of their service, right? What they're going to be doing, what they're really being elected to. All right, and so, well, I guess, hold on one second. So then here, there'll be a deadline. Once if you don't turn in your application by the deadline, you're not going to be on the ballot. Once the election coordinator gets all of the applications, she'll check them for accuracy, make sure that there's only 1 person per rented space, et cetera, et cetera. And then we'll fill out the ballot, complete the ballot. So here you're looking at an example ballot. So for the vote, the election coordinator shall, again, check applications, add candidates to the ballot, complete and distribute the ballot to every home in the park. They will manage the ballot box, and they'll keep records and obtain signatures. Facility tenants shall fill out and return the ballot by the stated deadline. As you can see here on the ballot, it's very clear that this is example parks tenant committee of 7 ballot, right? That's very clear at the top. There's general information that talks about what occurred before this vote. There's eligibility, which discusses who can vote and how many votes are allowed. The deadline is there, which says the date, the time, right? And and where the ballot box is located. It includes instructions for how to cast your vote. So here, it says fill in the bubble. A vote in favor of a statement or a candidate would appear as a filled in bubble, whereas a vote against a statement or a candidate would appear as a blank bubble. Then you go down, that's vote 1 of 2. Cast your vote for the statement you agree with most. You may vote for only one option. Do you want to create a tenant committee of 7 at example park? Yes, I want a committee of 7. No, I do not want a committee of 7. And then you would fill in the bubble next to the statement that you agree with. Vote 2 of 2. Cast your vote for the candidates you wish to elect as members of example park tenant committee of 7. You may vote for up to 7 candidates. So here you would have the name of the candidate, the space, the candidate's space. And this helps ensure that, for everyone, makes really clear that only 1 person per space is running, right? If you've got 2 of the same numbers here, then the election coordinator should flag that and make sure that they're only including 1 of those people. So then in order to vote for your said candidate, say I want to vote for candidate 1 through 7, I'm going to fill in these bubbles 1 through 7, leaving 8, 9, 10, and 11 completely empty. Then at the very bottom, there's the voter certification and signature, where you say, I put in your name there, certify that this is the only vote being cast from my rented space, the manufactured home I reside in, and is owned by myself or someone I live with. I have reviewed and completed both sections of this ballot. You'll put in your space number and your signature. right? So it's important that this space number is included because that is how the election coordinator and the tally assistant are going to determine that only one vote per rented space was cast in the election. So again, I mean, this type of a vote, this type of ballot, you can change it if you want to, but and I do think that I have a slightly updated version that has a time here that adjusted this area. I think I forgot to upload it to my PowerPoint, and I apologize for that. But when these things are posted online for your guys' access, I will make sure that it's all correct. But essentially, you know, the point of the ballot and having all of this information in it is that landlords do often object to the form of the ballot. They object to whether you've given residents an opportunity to vote against establishing a committee of 7, and that they've objected that they don't give you an opportunity to say vote against someone, right? Whereas this setup makes clear that if you want to vote in favor of someone, you need to fill in the bubble. If you want your vote to be against that someone, then you just leave it blank, right? So you're making sure that tenants have all the options, and that you have the 2 different votes, right? Whether we are going to set up a committee of 7 and then who will be on it. And then also making sure that the eligibility and the deadline and all of that kind of stuff is out there and available on the ballot. This is a huge objection I see from landlords all the time. I worked with a group where their ballot didn't even say the word ballot on it, right? And so there are things that things like that can basically completely derail your election. And so you know, I hope within the next week, these kinds of documents will be made available as a packet across our different websites, and you will have access to obtain all of these for your own use as well. And I see that Ken's got a hand up here.
Yes, I'm curious. The statute doesn't state that there has to be a majority or any specific number of people that are contained in a tenants committee or committee of 7, max is 7 officers. But I don't want people to think that if they don't get a majority of people that want to have a tenants committee, that they can't have one. All it takes is, you know, several people that want it, as I understand it, and that's really enough.
So again, you're looking at the statute and trying to interpret it in a way that is most beneficial to tenants, right? Whereas I'm looking at this statute and trying to interpret it the way that a landlord would, because at the end of the day, the only way for this committee to have power is for your landlord to recognize you. And if you do a park-wide election and 87% of the people vote against having a committee of 7, and you try to argue that you do have a committee of 7 in that situation, I would not take that case to court. I would not fight on behalf of that committee because that is not a reasonable position to take, right? And so, or at the very least, there is a reasonable position against that, right? And so my point here is that I'm only one person. I can't take on every single case when a landlord is not recognizing you. And if I tried to do right, and if I tried to do that, that would be a huge waste of resources. And so the way that I'm approaching this is, let's make sure if tenants can take every step possible to follow what that statute says and to deal with any objection a landlord may have, and the landlord still at that point won't recognize it, then I think that's a meritorious, that's a good case to get involved in.
No,
But
I don't object to that at all. I guess what I'm suggesting is we don't want people to believe that unless they get a majority of people that want to have it, I mean, where do you draw that line?
so Ken,
people,
if you've distributed your ballot to every single person in the park and only 4 people return their ballots, but those 4 people say, I want a committee, I think you can go ahead and form a committee in that situation. If those 4 people say they don't want a committee, then you can't form a committee in that situation. So the park-wide vote, by saying you're holding a facility-wide election, that, that terminology necessarily means that the majority of votes returned will determine what the results are, right? So it's not, you're not going to say, well, there's 100 people in my park and only 80 ballots were returned. So we're saying that that's 80 we're not looking at the total amount of spaces in the park. You're looking at the total amount of ballots returned, right? So if out of those 80% of the park that returned their ballots, 60% vote in favor of having a committee of 7, then you get to establish that committee of 7. But if 80% of the park return their ballots and 45% say they want one and 55% say they don't, necessarily that means that you do not have a committee of 7, because the majority of your park voted in election to not establish a committee of 7. I mean, that is what an election is, right? Is that the majority of votes that are cast will determine the results. So again, it's not, the results are determined by the amount of ballots received, and the majority, the majority of the choices in the candidates from that, the ballots received. You would not count a non-returned ballot, right? If 20% of the park doesn't return a ballot, you're not counting those votes against forming a committee of 7, right? We're not dealing with those votes at that point. Does that make sense? I feel like I've now made this more confusing. Okay. So results in commencement. So the election coordinator and the tally assistant shall check the ballots and tally the results. Checking the ballots again, like I said, is basically what they're doing is just determining that only one vote per rented space was cast, and that the ballot was filled out correctly. If more than one ballot was cast per rented space, or the ballot was not filled out correctly, then the election coordinator and the tally assistant should make efforts to get that ballot corrected by reaching out to that tenant or that rented space, explaining the problem with their ballot, and allowing them about 24 hours or so to submit a corrected ballot, right? So in my example park tenant committee of 7 election results notice here, you can see towards the bottom, I say 2 ballots were cast but were not counted because the voter was ineligible to vote in the election. Both ballots were flagged because they indicated the voters lived at the same rented space. Election Smith and Tally Thompson contacted these voters on March 16th to explain that they had submitted 2 ballots in the election when they were allowed only 1 per rented space. The voters were given a new ballot and asked to submit their vote as a unit on 1 ballot. The voters were given an additional 24 hours to submit the single ballot. The voters submitted the single ballot by the new deadline, and the vote was counted, right? So essentially, the election coordinator and the tally assistants should do what they can to make sure that everyone's voice is heard in the election. And if someone has made a mistake on their ballot that would otherwise make it ineligible, they should make some efforts to try to correct that. Here this is kind of what Ken was saying, that even if you don't get an actual majority of the park, right, meaning that if there's 100 people in it and only 50 people vote in the election, well, you don't even have a majority of people voting in the election, right? And so, but that, again, that doesn't matter. It's out of those 50 people that voted, what did the majority of them want, right? So here you can see where we have, in my example park, there's 84 spaces, eligible spaces in my example park, but only 65 ballots were cast in my example park. Here, 2 of those ballots were actually rejected because they were repeat ballots, right? But another one was put in. So out of this, really, we counted 63 ballots, right? Does that make sense? Because we rejected 2, so we counted 63 ballots out of the 84. We're looking here, at 75% tenant participation. Again, that's 75% of the park participated. That does not have anything to do with the results, right? Just because only 75% participated, the results are determined by what that 75% said they wanted, right? So the other 25%, they don't count as no votes. They don't count as any votes, right? They're just kind of taken out of the running. Then on the second page, we're going to have the election results. So you can see we've got similar boxes that were on the ballot to reflect how many votes were received. So under the question, do you want to establish a committee of 7? 56 votes were cast for yes, I want a committee of 7. That's 88.9% of the votes that were cast, right? So out of the 65 votes, that was 89.9%. I do not want to, or excuse me, it would be 63 because two were rejected. So, and then 7 votes for no, I do not want a committee of 7. That's 11% of the vote. So when you're thinking about the percentage, when you're looking at majority, you're looking at the majority of the people who voted, right? So in this sense, yes won overwhelmingly, right? Almost 90% of the park or of votes cast said they do want a committee of 7. So this park has a committee of 7. Oh crap, I'm so sorry. Here, so we're going to list all the example candidates that were on our ballot. And we're going to put how many votes each one of those received. Example candidate 1, every single person in the park voted for that person. They are rank 1, they got 63 votes. Then example candidate 2 got 62, moving down the list, 61, 60, 59, 57, or 58, 57. Now we're getting down to example candidate 8, 9, 10. They only got 10 votes, 6 votes, and then 5 votes, right? So those people did not make it onto the committee. We're going to take that those top 7 candidates, and that's going to be our committee. Then you're going to have the last section here. You've got a sentence that says a majority of example park tenants voted in favor of forming a tenant committee. The following candidates have been elected to the example park tenant committee of 7. You're going to put their names, their space number, and some contact information for them. This notice is going out to the tenants. Again, it's important that tenants have access to their committee members. And so either put out their phone number and email, or just phone number, whatever it is, but you need to have good contact information available for all of your committee members. It's free to set up email addresses. I highly recommend, once elected to a committee, setting up a committee email address, something like exampleparkcommittee7@gmail.com. You could even, once you've appointed once you've appointed positions within your within the committee, you could say, you could set up one president committee of 7 at example.com, right? Whatever it is, but you should have email addresses for each person, and you should have an email address for the committee as a whole, and that information should be distributed to tenants. So it is the election coordinators and the tally assistants' responsibility to put together this document and to notify all of the candidates of the results and to distribute this notice to all the tenants in the park. Once that is done, the elected committee members need to host or need to have a meeting together, an internal meeting for themselves, where they will develop their policies and practices and appoint different positions within the committee. And then they need to host a town hall for all the park tenants. And also they need to make sure that the landlord, which is the next one, but that the landlord is notified as well. So once the committee is elected, they should hold an internal meeting, appoint their positions, start creating their policies, practices, and goals. Then they need to host a town hall to get input from all of the other tenants on those policies, practices, goals, mission, etc. Remember, this is supposed to be a collaboration, and it needs to be very transparent So any of those documents that the committee makes, those should be distributed out to tenants as well. The last thing that you need to do here is that notify the landlord. And so the election coordinator shall draft an overview of the election process and transfer all election records and the summary to the new committee. As you saw, the notification of election results contains an overview of that election process. So as long as the election coordinator transfers all of their records, as well as the notice to tenants of the election results, and that notice has a good summary on it, then that they've done what they needed to do. But the committee members shall draft this letter. The letter is very similar to that of the notification to tenants. Essentially, you're going to be explaining, here are the rented spaces in the park. This is how many ballots we gave out. This is how many ballots were returned. This is how many ballots we counted. This is how many votes were in favor of forming. This was in votes against forming, right? So, and then you'll list the people who were elected to the committee and the amount of votes that they received. And then, of course, like I mentioned before, at the end, you want to make sure that you include, a little blurb there that says, we have the right to meet with you, but this is not an intended request for that meeting. We just have formed this committee and we want you to know that. We did hold a park-wide election as required, and please respond to let us know that you've received this, this notice and that you recognize us, basically, right? Here at the bottom, I have attachments. So it says document tracking spreadsheet, ballot, and vote count. So what you're going to want to do with this letter is attach, the records, the election records. So if the election coordinator was collecting signatures or keeping track of who got a ballot or when they were distributed and how they were distributed, that should be just submitted along with your letter. A copy of your ballot should be submitted along with the letter. A copy of the kickoff meeting flyer should be submitted, as well as any like tallying or vote count document that was created by the election coordinator and the tally assistant when they were actually tallying the votes. And then other than that, you're basically just giving a narrative version, a narrative overview of how you held the election and what occurred in the park. So what meetings you had, what topics you discussed, who or how many people were present, that type of a thing. All right, so we're going to go now into some of the rights and duties of a committee of 7, but I wanted to pause here and see if we have any questions about the election process before we move on to rights and duties. Okay, not seeing or hearing anything, I'll go ahead and move on. So, committee of 7 rights. The committee of 7 can compel the landlord to meet with them at least once per year. In order to get that right, or order to exercise that right, I should say, the committee needs to send the landlord a written request to meet. And they also need to send a written summary of the meeting to the landlord after that meeting. The landlord does need to respond to that request and try to meet with the tenant committee within 10 to 30 days after receiving the request to meet. Generally speaking, that meeting should be held on the premises of the park. If there is some kind of a rec room or meeting room facility that is appropriate for that type of a meeting. If that type of facility doesn't exist at your park, then the landlord can schedule the meeting to be at another place, but it does need to be a place that is convenient and accessible to tenants. The committee of 7 has the right to use common areas for committee purposes. So the landlord can't prohibit use of common areas for the committee's purposes. So for either holding an internal meeting, for holding a town hall, the landlord can't prohibit you from doing those things. it is your right to organize as tenants in a park, and it is your right to access the common areas and facilities at your park. And your landlord cannot prevent you from using those common areas or facilities simply because you are organizing as tenants when you're using that space. They also can't charge you fees for those spaces. They can only charge you a refundable deposit for those spaces. So that's something that you should be on the alert for. Oftentimes landlords will attempt to close down these facilities or refuse access to these facilities, and will give kind of a bogus reason like, oh, you made it really dirty the last time you used it, or you didn't return things to their proper place, or you didn't pay the deposit or give us enough notice, or whatever it is. So whatever the rules are for your common areas and facilities, make sure that you're following those to the T as the committee when you're using those common areas, and make sure you keep good records, right? Take photos of the meeting room as you walk in, take photos of the meeting room as you walk out. If the landlord wants to argue that you left it super dirty, well, you've got pictures to show that you didn't, right? So just kind of making sure you understand what the rules for those meeting spaces are in your park, and then making sure that you're following those rules and keeping a record of how you're following those rules. So if your landlord does try to argue that you've broken those rules in some way, so now you're prohibited from using these areas, you've got the proof that you need to show that that's untrue, right? Another right that the Committee of Seven holds is the ability to canvass the park and organize. So the landlord cannot prohibit tenants from canvassing a park or organizing. That means that tenants are allowed to go door to door, to distribute handouts and flyers, to discuss park issues, notify tenants of upcoming meetings, all that good stuff. A landlord can't prohibit you from going door to door, from handing out information, from distributing flyers. Simply cannot do that. However, the caveat here is that if a tenant tells you they don't want to be canvassed, they don't want to receive these notifications, they don't want you to come door to door, then you do have to respect that tenant's wishes. Again, this is another reason why I think it's a good idea to have some kind of online presence as a committee, because going door to door is the most effective way to get information out, but it's always nice to have that information posted either on a Facebook page, and Instagram page, or a website if you're feeling really spicy about it, right? Or even you just send out, you have an email list and you send out email blasts with this information as well. But it's great to have the information come in multiple different ways, say via email and in person. And again, always keeping track of how you're canvassing, how you're getting information out to tenants, because often landlords will object, say that you didn't get the information out to everyone. So just ensuring that you have records that you did get that information to everyone, that's a really important part. Again, we talked a lot about this above, but one of the huge benefits and one of the rights of a committee of seven is to organize and offer to purchase the park, only if the landlord has served an intent to sell. So basically the law specifically states, in order to compete to purchase the facility within 15 days after delivery of the notice, the tenants must form or identify a single tenants committee for the purpose of purchasing the facility and notify the owner in writing of their interest in competing to purchase the park. So where it says there that they can identify a single tenants committee, that just means that you can identify the committee of seven to act as that tenants committee for the purpose of purchasing the facility. But of course, the tenants of the park must consent, which is why I think that it's worth it to host these town halls to discuss the possibility of a park purchase in advance to receiving some kind of a notice of intent to sell, because 15 days is just not very much time to get that consent from every person in the park, to then send in that, to get the letter that you need, and then to send that into your landlord. So, discussing whether or not your park would like to form or would like to compete in purchasing a park, I think is really important. Having a plan in place for how you would call that meeting together once that notice is received, I think, again, super important. Just being prepared to deal with this situation, should it arise, is a really important part of the committee of 7, because 15 days is just not a lot of time, guys. So making sure that you've got some things in place, and you know what you're going to be doing should that notice come to you. Huge benefit. So some of the duties here of a tenant committee of 7. So the tenant committee of 7 represents the interests of facility tenants in your park. You need to have open dialogue between the committee and the park tenants. The committee should establish an email address that all of the members have access to. They should host town halls. They should collect tenant complaints and concerns and use that information to determine what issues they will raise with the landlord. And the committee should make all of their adopted documents available to tenants. So, I suggest that the committee put together 2 documents, one mission and goals, and the other practices and policies, or practices and procedures. Those documents should be made available to tenants. It shouldn't be a secret how the committee operates, or what the committee's goals are. That, you're there to represent the tenants, therefore tenants should have access to everything you have access to. The tenant committee must draft and send written requests and summaries to the landlord. So that's a huge responsibility of the committee. The committee must be able to produce written documents in a timely and professional manner. So when you're looking for people to run for the committee, or you're thinking about running for the committee, you want to make sure that you have the ability to, use the computer, use Microsoft Word, be able to type up a letter, understand how to put things together in a professional manner, right? And be able to have some time management skills here too. Again, the committee needs to make all of the written documents that are provided to the landlord available to park tenants. The committee should not be having secret communications with the landlord that are not disclosed to the tenants. That's really not the purpose. Of course, if the committee has just an oral conversation and it's not of any consequence, you don't need to notify the entire park of that. But if you're sending the landlord a written communication, that should be something that is shared with tenants. And again, there are ways to share this information without being overly burdensome. If you have a Gmail account, if you've set up a Gmail account for your tenant committee of 7, you can use a Google Drive account or a Google Drive that is connected to that email account, where you can post all of the committee of 7 documents and letters and things that you have sent, and you can share that that drive with every tenant in the committee so they can access that information remotely as well, right? So there's a ton of ways to make the information available. The bottom line is that you make it available and make it available in more than one avenue, right? So if it's all available online, make sure that someone in the committee has hard copies of those documents that they can provide to tenants should they request a hard document or hard copy. As we know, there's lots of seniors, lots of kind of tech illiterate people in these parks. So not everyone is going to be able to use an online resource. So just making sure that, how you're communicating and providing information and documents to your tenants is in alignment with the tenants that you have in your park and the ways that they prefer to get information. Another duty of the committee is to discuss park issues and concerns with the landlord. So the committee must be able to raise issues and concerns with the landlord based on the information collected from park tenants. Again, the committee is not there to make their own judgment calls and their own decisions about what is wrong with the park. They are there to collect the information from the tenants, to consolidate that information, and to use the goals and the mission that have input from other tenants to decide what is the most productive and professional way to have the discussion around these issues and concerns, right? That's kind of the The professional productive manner, that's that falls into the committee's purview, right? But what issues and concerns are raised, that really is about the interests of the tenants, right? So that can't just be an internal decision of the committee. The committee needs to elicit and incorporate input from the other facility tenants in order to determine what those issues that are going to be raised are going to be. The committee needs to appoint roles for each committee member. Now, this isn't, obviously this is not contained in the statute, but I think that it makes the committees run so much more smoothly when each person has a specific role, and that role, the responsibilities and the expectations for that role are set forth in writing and made very clear to each committee member. So for example, the way that I've set my example park committee of 7 up is I have a president, a vice president, a records officer, a financial officer, an outreach officer, and then general members. The president and the vice president, that's pretty self-explanatory. They're going to be the leaders of the committee. They're going to be the ones that are starting the meeting, are asking for consent from other members, are running the town halls and making sure that things are operating in a professional and smooth manner. The records officer is going to be the person who's taking minutes, is making sure that documents are available for tenants to access, right? They're going to be the ones that are ensuring that whatever was discussed in the meeting with the landlord is included in that written document, or written summary, right? So the records officer has a really important role here. They're going to be the one that is in charge of creating and maintaining all of the records of the committee. And those records, again, would be your evidence, right? So should something come up, those records are going to be what are going to build the evidence for a case. So it's an incredibly important role. There's going to be a financial officer. This role, I think, is it could go either way. You don't really need this role, or you do, depends on how you run your committee. Some committees have opted to, request small donations in order to host or, get food for town halls, or to book a meeting room should there not be a rec center available at the park, right? Or, I know one park collected some funds so that the election coordinator could buy a locking ballot box, and had money to go ahead and make all the copies of everything, right? So if your committee collects any sort of donations or deals with money in any kind of way that comes from the collective, you should have a financial officer who is keeping track of that money, keeping track of where it goes, how much is left in the account, and is making sure that those funds are being spent in an appropriate manner and are not being appropriated for personal use or other use, right? The responsibilities and expectations should be drafted and adopted as part of that committee's practices and procedures. So like I said, I think each committee should have 2 documents: your mission and goals document and your practices and procedures document. The practices and procedures will set forth who has each role, what that role is, what the responsibilities are of that role, how long the term of service on the committee is, how you can remove a committee member from the committee, how often the committee is to meet internally, how often the committee is to host town halls, those types of things, right? So setting forth the practices and procedures at the very beginning, drafting them, adopting them, and of course that can be a working document that you continue to work on as things come up and you realize, hey, this is something we really need the committee to do. Let's adopt a policy or a practice about that, so that we can do it and be consistent. One of the real benefits of having these documents is that if there is turnover on your committee, if you do have people who want to step down or people who have been removed either by a special election or for failure to participate in the committee or, meet their roles, right? If you get elected to the committee and then never show up to anything and never do anything, you want to have a practice or a procedure set in place where you can remove that person from the committee, because at that point they're dead weight. You need their consent to do something, but they refuse to give it because they won't ever show up, right? And so you want to be able to have practices and procedures about how to deal with potential problems that will come up during the life of your committee. And you don't necessarily want to be creating all of those policies ad hoc as you're dealing with it, particularly in setting up expectations and policies around, what kind of thing do you need to do in order to basically lose your spot on the committee. Having that removal or step down policy at the beginning of the committee's life, I think, is really important, and that definitely should be in that document. As we said here, so there's an overall mission and goals, and then basically your procedures are how the committee will run. So how are you going to collect input from park tenants? Are you going to send out emails and ask for email input? Are you going to just have town halls? Are you going to have a suggestion box? Are you going to have an email address for complaints, right? So these kinds of things, right? Like, you want to really think, what's the function of this committee? How are we going to run that? And then you want to think about some of those more like housekeeping items of, how are we really going to get this committee to run? What happens if someone wants to step down? What happens if someone fails to participate? Right? And so the committee should get together, discuss these types of policies, and draft and adopt those policies. Adopting the policy is done through consent. So one person would say, I present this policy for adoption. I move that we adopt it, and then they would need to get consent from the other committee members to adopt that rule. The last thing that is a real duty of the Committee of Seven, and is something I talked about quite a bit before, is that the committee should be a resource for facility tenants. So the committee is in a unique position to help tenants access resources that are available for their particular issue. So if a tenant comes to the committee with a particular issue, the committee should have a list of available resources that is separated by issue. So for example, if a tenant came to the committee with a termination notice that had been filed in court and they have a court date set, the committee should know that the eviction defense project is available in that situation and give that tenant the eviction defense project's number, right? So and as the committee continues to do this work and is around for longer, they're going to learn of new resources, and there'll be new handouts, new information that's available. And so they should be consistently updating that list as those situations arrive and they discover new resources. Now, I think that part of this kind of resource for facility tenant should somewhat fall under that outreach officer. Now, the outreach officer should not be responsible for doing all of this stuff, but perhaps that outreach officer is responsible for keeping that list, and perhaps they're the ones that are responsible for monitoring the email, right? So again, you just need to set forth those duties and responsibilities for each member at the beginning of the committee, when you're first forming it, when you first appoint those positions. Because if not one person is responsible for it, oftentimes what happens is that everyone thinks that someone else will do it, and then it just doesn't get done. And that really defeats the purpose of having this tenant committee. The tenant committee is supposed to be here as a resource for tenants, something that is going to empower tenants, something that is going to, raise the morale and strengthen your bargaining power. And if you are kind of sitting on the issues, if you don't know what your role is, if you're not the one that's responding, you can be a really ineffective tenant committee, and then you're not really serving the purpose of the committee, right? And so I think making sure that each and every person that's on that committee understands their role, their responsibilities, and that each and every one of these duties is considered when you're separating those duties up between the different members, right? That you make sure that all of these duties are covered, and that there is at least one point person who is responsible for making sure that the thing has been completed. Now, of course, they don't need to do the work all by themselves, but you just need to have one person that is responsible for making sure it at least has been done, right? Checking to see if it's been done. And if it hasn't, then they can bring that to the committee and say, how are we going to get this done? But you want to have, each person should have ownership over their own role and bring those issues to the committee for discussion. All right, and the last thing here is that there are resources available. Oregon Law Help, it's available at oregonlawhelp.org. I do believe that website is down today. It is going through we're basically redoing the website, I believe. So if you try to go to that link today, it will be broken. You can't find it. But that link should be back up, I believe, on Wednesday. And that we're adding a whole bunch of new documents to that website. So that's the website where you're going to be able to find most of the committee of 7 documents, sample ballots, all of that kind of stuff will be posted on this website once we get that new site up and running. There's OSTA's website, OregonTenants.com. The plan is that I will be sharing anything that I post on Oregon Law Help. I'll be sharing that with OSTA and MMCRC. So all of those same documents should be available on those 3 websites. So you should be able to go to any one of them and find the documents there. I will warn you that they are not there right now, but they will be there hopefully next week. I need to get approval from my higher ups now that everything is in the right format, and just make sure that they're good with sharing it, and then those will get shared out. So again, like I said, hopefully within the next week, or by Monday next week, these first 3 websites will have all of the documents you saw here, the example documents you saw here in my presentation will be posted there. You can also find legal information and potentially legal resources at OregonLawCenter.com or .org or LassoOregon.org or the Oregon State Bar website. These websites will give you information about our local offices and how to apply for services. Oregon State Bar does have some legal information on it. Again, neither myself, Oregon Law Center, Ken, MMCRC, or OSTA really have any say over what Oregon State Bar posts on their website. So it's kind of a hit or miss what's up there. Sometimes they'll ask one of us to write a summary and then get it up there. I believe what's posted on their website right now is old and outdated. So hopefully at some point in the future, they will update that. But again, that website is not in the control of the people who are here at this meeting or that are doing this type of work. But the Oregon State Bar does have a modest means attorney referral program. So if you are looking for an attorney, start at OLC and Lasso. But again, that financial eligibility requirement might be a barrier for you. Mine is higher, but again, I'm only one person. And so I'm not always available to take on new clients, right? So if OLC and Lasso don't work out for you, then you can go to the Oregon State Bar, do that modest means referral program. They will give you the name of an attorney in your area that's signed up for this program, and you'll be able to have a 30-minute consultation with that attorney for $30. After that initial consultation, the attorney will set their price scale depending on that attorney, right? So it's different for each attorney. Basically, the modest means program simply gets you in the door for a consultation for that small price of $30. Oftentimes, modest means attorneys will use what we call a sliding scale, like a sliding scale fee schedule, where they will look at your income and set their fee based off of your income rather than their experience, rather than just their experience alone. On that sliding scale, you're gonna get a much lower price for the attorney, right? And even young attorneys with 5 years experience or whatever, generally speaking, that's around $250 an hour in Oregon. So the $300 or $30 for a half hour is a great deal. And most of the time, those modest means attorneys will try and do a sliding scale with you to get that fee down to something that you can afford. Yes, so Q&A. Again, this is not legal advice. I can't answer questions about a particular situation. I can't apply the law to the facts of your case. But if you have general questions about the Committee of Seven, about Oregon Law Center, about really anything that I discussed in this presentation, happy to talk about that. And also, if you have a question and you're not sure if it's legal advice, feel free to ask it and I can just tell you, sorry, I can't answer that question. So yeah, please, the floor is open to anyone who may have any questions, concerns, comments, anything. We've got just a few more minutes left. Yeah, go ahead, Ken.
Yeah, you might want to mention about who's allowed to attend these meetings. Oftentimes managers will see the audience with, colleagues or whatever. And it's always been a question about whether or not an employee of the park can attend some of these meetings because the statute allows the tenants to meet in private. And, how do you differentiate that? And that seems to be a question that, people have had.
So yeah, I think if the person is considered a tenant of the park, then they would be allowed to attend. So a tenant of the park, so a manager who lives in the park would not be a tenant if they receive their housing as a condition of their employment. So if that person doesn't pay space rent because they are the manager and that's part of their employment, right? Part of their employment contract is that they will be able to live in this space for free, then that person is not a tenant and that person does not have rights under Chapter 90 as a tenant. And I would argue in that situation, those people would not be allowed to attend the meeting because they're not a tenant, right? So if they're not, so you have to make that determination. Is this on-site manager a tenant or not? Do they pay rent, or is their rent, is their housing at this park conditioned on their employment? That's really the test to figure out whether this person is a park tenant and then therefore has to be included in these things, even if they are an employee of the manager, right? Because they would still be a tenant. And this right belongs to tenants, versus if they are really not a tenant, if they're excluded from Chapter 90 because their housing is conditioned on their employment, right? So that determination would have to be made, and that's a legal determination that you'd have to look at the facts. You'd have to look at the facts in each specific instance to determine whether they would be allowed or not. But yes, generally speaking, most of the time, I think on-site managers would be excluded from Chapter 90 because most of the time their tenancy is conditioned on their employment. But it would be very clear that like an outside manager, right, or a regional manager or someone who doesn't live in the park, that's pretty obvious, right, that person's not a tenant. So you don't even really need to do a determination there. It's really those on-site managers that get confusing, right? Because they live in the park, but they're also a manager. So how do you make that determination? And again, it's just whether or not whether or not living there is conditioned on their employment or not, whether they pay rent or not, essentially. And I do think that, in terms of when you're holding an election, and handing out ballots and stuff, I have seen landlords object to on-site managers or like maintenance people not receiving a ballot. And in the case where someone is paying rent, but also has been hired to do maintenance and gets paid separately for maintenance, that person is still a tenant and that person does need to get a ballot. And so it does make sense, I think, particularly in the voting process, to just be cautious and like give everyone a ballot, right? But I do think that, you can ask, like, hey, you're my manager. I need to know whether you're a tenant or not to know whether you can participate in this committee and these meetings. Can you please tell, you can ask them, can you please tell me if your rent is included, right? Or you can ask another manager, and unfortunately you have to get the information from the horse's mouth, and the horse's mouth sometimes is not reliable. So I think we do understand that. And unfortunately, there's just not an easy answer. I think my inclination is to just be overly cautious and to allow them to vote in the election or to be there unless you really know that that they don't pay rent and that their housing is conditioned on their employment. Because if you exclude them and they're not, right? If you exclude them and they really are a tenant, well, that can destroy your entire election, because if you failed to provide them with a ballot and they really are a tenant, well, then you didn't hold a facility-wide election, right? And you might have to do it all over again. So again, this is why I say using caution makes a lot of sense. Just overdo it, be a little crazy with it in this process, because I think it makes way more sense to kind of do too much or go overboard in the first instance than having to do something 3 times or over, right? I mean, by the time you get to that third election, no one wants to do it anymore. Everyone feels defeated, and the whole benefit and purpose of the committee kind of dies out because you've wasted all of that energy and excitement just trying to fight with your landlord to get the committee established. And that really is why I present you guys with this really strict, kind of intense election process, is so that you have all the steps, all the resources, everything you could possibly need provided to you. And it's very unlikely that your landlord is going to be upset about this process if you use this process. 4 parks have used this process so far since I've developed it, and all 4 parks have been recognized by their landlord, including a park that held 2 elections where the landlord failed to recognize them after both elections, having objections. They used this process, and now they've been recognized after using this process. So I do think that it's effective. We've seen it fix the issue for a park who did 2 elections unsuccessfully. It fixed that issue for them, and now their landlord recognizes them. So we know that this process is effective. It will work to get your landlord to recognize you. And again, like I said, if you follow this process and your landlord still is failing to recognize you, well, then that's a situation that I would be interested in litigating, or at the very least negotiating with the landlord. Because if you've done everything that I've set forth here and your landlord still won't recognize you, I mean, there's just no reasonable reading of the statute that could possibly require anything further than what I've set forth in this presentation. And then I would argue that your landlord now is no longer taking a reasonable position, right? The other objections I've heard from landlords, I think, are reasonable, and it really would just depend on who the judge is in front of you, whether they would agree or not, right? And so for me, when I think about taking cases, I don't want to be in that position where the other side is reasonable. Especially for something like this, where we can just preempt the problem by using a better process. I think it makes a lot more sense in terms of, let's use this better process. If landlords are still being crappy about it, then we'll go to bat on it, right? But we're not going to go to bat for a mediocre process. We'll go to bat for a real robust one, right?
Well, thanks, Samantha. Appreciate everything. We're over on time and want to be sensitive to everybody's schedules. Thanks everybody who attended. Looks like to Jim, I think you're the last man standing. But thanks for attending, and hope everybody has a good day. Anything remaining you need to say there, Samantha, before we sign off?
No, I was just going to say that if we can just get this posted ASAP, and if you guys wouldn't mind just shooting over the link to me and OSTA, and we'll get that link posted for anyone who wasn't able to attend.
Judy, you get on that? Is that, am I speaking out
I'm-
of school there? Okay.
Nope, I'm gonna try and get it to you by this afternoon.
Fabulous. Thank you so much, Judy. And thank you,
Yep.
Rick and Ken and everybody for all your help. And thanks, Jim, for joining. And hopefully we'll see you all soon. Have a great rest of your day.
Okay, everybody take care.